Yes.
Try not to wear this in traffic.
Please don't.
Just hold this here. Afternoon, ladies and gentlemen. It's always fun to watch a person who's been hired to represent somebody check not guilty boxes. It's like the car dealer handing you what they think you should pay and you have to pay it. Makes no sense. We're here to talk about evidence, we're here to talk about testimony, we're here to talk about facts, and these are all things that find Mr. McDonald guilty of the crimes we've charged him.
Mr. Raman, I think it's actually easier if you just turn that off.
I would love
hear
to.
you, and I confirmed with the court reporter that we can hear you, so you're good. All right, sorry to interrupt you.
Thank you very much. Ms. Mishler did start this trial talking about privacy. Now, the facts as you have them are very troubling. A woman who is in teaching for 7-8 years, been at Bonanza High School as an English teacher for about 5 years now, so during the time of these events, she was a high school teacher, encounters her divorce proceedings online. Now, that's not a crime. That's a bad thing, but not a crime. But where it does become a crime is she hears her private phone calls between the man she is divorcing being posted on a YouTube video, not once, but twice, that she did not consent to those recordings, nor know that she was being recorded. And there's a photo montage of, as you've heard from Mr. DeCiro, pictures from her home journal. A picture of her in her bra and panties. This is a high school teacher. These are private conversations, and we have laws against this. This case has everything to do about privacy, and we have laws to protect people for when their privacy is violated. This is one of those instances. Now, the defense's claims here fail. They're trying to confuse you, and confusion is not a defense. They keep talking about, oh, there's these different versions. Everybody knows. What happens is Michael, through conversations with Mark DeCiro, gives him links to his Google Drive. One of the folders has a ton of information. Over the course of maybe a month or two, he reviews that information. Then later on, much later, Michael posts this YouTube video, years later. And he finds that familiar. Where did I hear this stuff before? Oh, it's in Michael's Google Drive. That is not a different version. That is something that he posted. That is the privacy violation that I've talked to you about. That leads us back to the crime. The crime was not posting the YouTube video. The crime was recording the phone calls in the first place. The YouTube video makes it sting. Confusion is not a defense. He can't mismatch the facts, get you guys caught up, and then walk his guy into a not guilty. That's not how it works. Facts here are actually very easy. Now, the defendant would like you to believe that you should go to this instruction 19, which is the common sense instruction in health. We mentioned it, and we said you should use your common sense, and that's true. However, that is not a substitute for the beyond a reasonable doubt instruction. I've underlined these portions about don't speculate your way out of a verdict. Doubt must be actual, not mere possibility or speculation. Very important. You can't common sense your way out of the mandate under the law of the state of Nevada, and frankly in every state of this great union. This is the standard under which people are tried and found guilty or not guilty. Common sense has nothing to do with that. Common sense leads you to inferences on how to evaluate evidence. So these things are self-evident. We only presented 3 witnesses. You have a handful of things in evidence. One of them is a disc of audio, one of them is a divorce decree, a bunch of email things, some Facebook posts. But most of what is important in this case is self-evident, which means it proves itself to be true. It corroborates the statements of the witnesses you heard from. These are phone calls between Michael McDonald and Candace Ruiz. You know that because their voices are identified by the parties. They call each other Michael and Candace. They're speaking about topics that are pertinent to those 2 people. I'm not even going to dwell on it. There's no doubt it's Michael and Candace on these phone calls. They are recording of telephone calls. As much as the defense wanted you to hear, okay, it's just an audio file on a computer. They are telephone calls. Candace testified it was a telephone call, and the independent circumstances corroborate. There's distortion that you hear, that everybody in their common sense knows. The person that you're listening to over the phone, their voice is going to be distorted because it's coming through a speaker. The person who is talking in the room, their voice will not be distorted. You can tell from these calls, one party's voice is distorted, the other's isn't. But there's other interesting tells about it. The way that they're talking to each other, you can tell they're not in the same room. It's not like somebody, Candace or anybody else, surreptitiously put a phone recorder or some kind of digital recorder or even just a telephone app in the room and the conversation is going on between these 2 parties. You can tell by the content that it is a phone call. Now listen to this, it's very interesting. I'm sure that all of you have already picked up on this, but I just wanted to play this for you.
You hear somebody of doing something that horrific and disgusting makes me concerned.
How could you say that?
Okay.
I'm their father.
Because
You're
you're a psychopath. Who would ever suggest that? I'm telling you, all the paperwork has been used, and she has a personality. She's constantly disgusting to you.
Yeah, Candace, like...
Okay, I'm not going to sit here and argue with you, but next time she has a doctor's appointment, you need to tell me. Because I'm concerned that she's not at school.
Yeah.
Like, you need to tell me that next time if she has an appointment. That's where I'm keeping. Like, just don't want to necessarily know if she has an appointment. She's not having to.
Okay, listen though, Candace, like, what... Like, I just want to make sure they're safe. Like, I should...
So obviously you can hear how tinny Candace's voice is because it's coming through a speaker. You can tell how Michael's voice is not tinny because it's not through a speaker. It's clear from that you know Michael recorded these conversations and Candace did not. It wouldn't be possible for her to make her own voice tinny if she was right there with a recorder.
Objection, facts not evidence.
This is a common sense argument.
That's overruled. We can continue.
The other thing that's interesting here is the quality of the audio as far as it being louder or softer moderates during this portion of a phone call. This is from phone call number, I believe, 3. What I believe that looks like is holding the recording thing closer to the phone and then somehow away from the phone and then back closer to the phone. That's how that happens. Okay, that's a recorder in the possession of Michael McDonald. Because if it was in the possession of Candace, how would it get farther from her and then come back while Michael's voice stays at the same volume? That makes no sense. So there is no notice of recording or consent given. 2 different things. You're being recorded, or I understand it being recorded. Please proceed. None of those things exist in this case. Candace testified she was not advised these calls are being recorded, nor did she give consent. She testified, and the independent facts of this show this to be true. On the recordings, there are no advisements of this is being recorded or her giving consent. She speaks in a way that is not mindful of an audience. If a person is being recorded, they would probably choose their words more carefully. She does not speak that way. She uses profanity. She is repetitive. She is emotional. She clearly did not know she was being recorded. She's going through a nasty divorce. Why would she consent to her ex or soon-to-be ex recording her? That makes no sense. And don't you think that based upon the way these conversations are going and the way that Michael doesn't seem to get the information she's telling him about taking care of the kids, that she might tell him, why don't you go back and listen to what you're recording? Because you don't get it, Michael. We don't hear that. Pretty sure you would hear that if she knew it was being recorded. Both parties were in Nevada during these calls. You heard from Candace, was in Nevada during these circumstances. In fact, she told you exactly where she was during all these calls. You can hear background information that aided her in remembering exactly where she was. So the question is, where was Michael? So these things kind of apply to everything. He lives in Las Vegas. He worked at Geotab in Las Vegas. He has a divorce custody case in Las Vegas. But the content of the calls also help you. Content of recorded call number 1 shows Malia was with Candace when the call was made. She was leaving the daycare after finding out Michael hadn't paid on the daycare. Michael asked to see the kids, and he's offering to pay that daycare for the visitation. If he's not anywhere around Nevada, how's he going to pay that daycare? If he wasn't in town, why would he be asking to see the kids? If she were to say, yes, come see them right now, how's he going to do that? That makes no sense. It took place on a weekday because she's picking up from daycare. And she only brings the kids to daycare when she's working. She only works during the weekdays. He would have been at work that day, not somewhere in California. Not at, again, no evidence of this presented anywhere, a seminar. Content of call number 2 shows Malia was with Michael when the call was made. Not allowed to leave the state with kids unless written permission 30 days prior. Never did that. So he was here. Content shows he took the daughter to the doctor instead of the daycare, found out an appointment was canceled. Doctor's here. Therefore, he was here. Content of call number 3 shows he was in Nevada. It's the lengthiest call of the group. Over and over again, he asked to see the children. Again, wouldn't he fall flat on his face if he wasn't even here to see the children? He keeps asking, okay, Michael, come over and see the children now. Oh, sorry, I'm in Utah. I'm in California, maybe in a couple days. No, you don't hear any of that. There's no, how about when I get back, can I see the kids? It's, can I see the kids? He is here. Makes a bunch of statements about the whereabouts of Candace and the kids. It seems to sound like he knows she's not at work, even though she didn't tell him that. How would he know or care if he's not in the state? How could he figure that out from a distance? Call number 4 occurs outside the daycare facility. That was, again, testified by Candace. It was another weekday because we know it's daycare and the kids only go to daycare on the weekdays. Michael would have been working. He works in Las Vegas. He was here. Call number 5. It's a lengthier call. There's, again, no mention of him traveling or being out of town. He asked repeatedly to see the kids. Why would he ask if he's not present to see them? He was in Clark County. So ask yourselves, and this applies to everything, why would he leave the state and only then and there record phone calls? Or why would he only record and save phone calls when he's supposedly out of state? He wouldn't. Nobody does that. That makes no sense. There are plenty of clues that shows he was in Nevada during recording of these 5 phone calls. And they are, in fact, 5 different phone conversations. Defense wants you to believe, oh, it was only one that was chopped up. So, she testified it was 5 different phone calls. She gave you the context for each and every one. You heard for yourselves there are differences in circumstances throughout these phone calls. Emily is with Michael in one, and then she's with Candace in one. We know they're phone calls, that's not possible. There's a progression of info on Malia's diagnoses. So it doesn't just transpire during the phone call. Oh, we think she has an allergy to gluten. Oh, she has a gluten intolerance. Oh, the physician said so. Oh, then the surgeon said so. That happens over a series of time. You have the same thing with the divorce decree needing to be signed and then pushing forward without the signature. We have it with dating Joe, and then she's thinking of marrying Joe, which he throws a fit about because he thinks he has some kind of control over his soon-to-be ex-wife. And we have her driving a vehicle in certain conversations and then not driving a vehicle, based upon the background noise in her testimony. These are definitely 5 different phone conversations. I've already talked about it, but I want to let you listen to it again for your own. This is with regard to the divorce decree. From call number 3.
Sign the decree. I want to be divorced.
Can you let me see my kids, Candace? Like, please, let's...
Okay. Sign the decree, I want to be divorced. Call number 5.
That's scary from
I'm going to tell you right now, they've already submitted the decree. The court is going to sign on your behalf since you're refusing to sign. There will be nothing added.
Okay. If the divorce decree had already been submitted, why would she need him to sign the decree? These are 2 different dates. These are 2 different phone calls. That's just one example. I could play for you each and every one. You don't have to. There was no actions taken in this case of any ill intent or criminal other than Michael. No hacking evidence has been presented, even though Mr. Mueller got up and told you that this man hacked into his account. Nobody edited the content except for Michael. They were found edited in a way that was without hellos, without goodbyes in his drive. There's nothing in the law that says you have to wiretap an entire phone conversation for it to be a criminal violation. It's simply the interception and recording of a telephone conversation. Why no hellos? This is something my co-counsel actually made me interested in. After Mr. Mueller continuously said, oh, we don't hear hellos, we don't hear goodbyes. He probably didn't have his recording equipment available to him right then and there when she rang on the telephone. It probably took him a little bit to go get the recorder, turn it on, and mid-conversation start recording her. That's why you don't hear hellos. Simple as that. Makes a lot of sense. So all this bile and hatred, sure, if you forget all the context, it would be as if some kid, when I'm walking down the street, accidentally hits me in the shin with his metal softball bat. And I swear up a storm because it really hurts to get hit in the shin. And all of a sudden somebody gets up and says, that man hates children. You know, when you take out all the important stuff, sure, Candace had a lot of reasons to be angry at Michael. Clearly she had a lot of problems with the way he was taking care of the children when he did have custody of the children. So subtract all of the problems and just bring in colorful language and her disappointment and call her a manipulative person and call her somebody who had an axe to grind. But even if you did that, which you shouldn't, the evidence stands on its own. This man is clearly guilty. She could not have done anything to invent the circumstances that we have here today. Selective manipulation of the evidence is not a defense. Michael McDonald is clearly guilty of the crimes he is charged with. And this has been proven to you beyond a reasonable doubt. I ask you to find that verdict, be it take 5 minutes or 5 hours. Please do what is responsible, review, find, and convict. Thank you.
Thank you, Mr. Raman. All right, ladies and gentlemen, we're going to discharge you shortly. I do need the parties to approach the bench briefly. All right, ladies and gentlemen, so the time has come to tell you who our alternates are. Let me go ahead and let the alternates know who they are. That's Tyra White and Myra Rojas. You are our alternates. If you could stay behind, I'm going to chat with you briefly. The rest of you are going to head back into the jury room, but we first need to swear in both the marshal and Ms. Beltran as the alternative. They will be outside the door of your deliberation room that you usually take, so that they'll be your points of contact.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into the court when they have so agreed, so help you God.
All right. At this time, the jurors who are not alternates could please follow Marshal Stanley into the jury deliberation room. Be sure to bring you those jury instructions, the verdict form, as well as the exhibits shortly. I remind you that the first thing you're supposed to do is select a fourth person to begin the deliberations.
And over your notebook. All rise for the jury.
Let the record reflect that the jury, or the 12 jurors have left the courtroom. Everyone may be at ease and sit down. Good afternoon again. Thank you so much for your service. I do pay attention, and you all have been engaged and listening, and it looks like really pay attention to the evidence, so we certainly appreciate your attention. So there are starting deliberations now. We do have one juror who's supposed to leave town tomorrow. If they do not reach a verdict before then, we will have to reach out to one of you to come in to deliberate in that person's seat. And if that were to happen, I would instruct the jury to begin the deliberations all over again, so you would actually participate in the process from start to finish. So I ask that you do not talk to anybody about the facts of this case until you receive a phone call from my office letting you know that a verdict has been reached, and then you would be able to discuss the facts of the case. That is, again, for the same reason I've instructed you throughout the course of this trial. We want to keep it clean. We want to keep your thoughts on the evidence in your mind, and if you're called to deliberate, to then share it with your fellow jurors, because you are required to deliberate with jurors to reach a verdict. All right, any questions about that? Okay. I'm going to instruct the parties also not to talk to you in case we do need you to come back tomorrow or whenever they do not reach a verdict. So parties, please do not approach the alternates at this time. My judicial executive assistant has gone down to get you your juror checks. So I'm going to ask you just to sit tight for a minute, and those will be brought out to you. On behalf of the court and Clark County and certainly the parties, we thank you again for your jury service. I'm sorry you don't get to deliberate, but I certainly hope you found at least the jury process interesting. So please be comfortable. If you need to use the facilities, you're welcome to step out and do so. All right? Have you provided your contact information to our clerk?
No, we will, and we have a laptop in clean mode for the jury.
Oh, yes, please do. Thank you.
Judge, do you anticipate letting them deliberate past 5 if they want to?
It depends. So around 5, I'll check in with them and see how close they are, how far they are, and make a determination at that time. And then I'll have them come in as early as they want tomorrow. My courtroom is being used from 9 to 10 a.m. But if they want to come in at 8 to try and finish the process, I'll let them do that. So I'll give you a word update. JE should be up any minute now. She just went down to the third floor. Okay, just about to reflect that the alternate jurors have left the courtroom. I asked you to stay just so there wasn't any questions about Mr. McDonald's status.
Okay.
So, all right, thank you all. We'll give you a call as soon as we have more information.
That's not mine. That's the courts. They gotta keep, actually got some more guys to rule for. How late you gonna let them stay tonight, Judge?
I'm going to check in around 5 and see how close they are. If they're not anywhere close, I'll probably release them to come back tomorrow morning. We'll call you and let you know.
All right, thank you.
Thank you.
both did a good job bringing all this to my attention.
I'm going to make a record about you in a minute. You need to sit down and be quiet.
The court finds in the best interest of the minor child and makes the following findings.
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
Best interest is not, can you give her a pony?
I'm going to ask the question, make sure we're being accurate with what the document says. Okay, we're back on the record in case C-18-333-684-1. The record reflects the presence of the Deputy District Attorney, Ms. Mishler, Mr. Mueller, and the defendant. I'm going to let you finish putting that tie on, Mr. McDonald. Go ahead and take your time.
Good morning, Judge.
Good morning. Didn't realize I need you rush. Take a deep breath.
Mr. McDonald was held in a holding cell till 1 o'clock last night in the morning. 2. The next guy need dinner, Judge.
Sorry to hear that. I'm sorry what happened. I'm confident it had to do something with our late departure last night. And I apologize because the party that JEA sent an email for the communication error, so I certainly apologize for that as well. Are you comfortable with your tie?
Yeah.
All right, you want to take a deep breath? All right, all right. So we're going to bring the jury in. I did release the juror number 3 last night. He had to catch a flight today, as you all knew, to attend a funeral across the country. So I called, or my JEA called the alternate juror last night and asked her to be here, and I understand that the alternate juror is here. So I'm going to go ahead and bring them in, instruct them on what to do, and then they'll go back and continue the deliberations. Oh, and counsel, I did bring some breakfast treats for the jury, just so they don't know where they're from. They're already in there, but just so you know. And then we'll have them order lunch in about an hour, hour and a half.
Your Honor, if I recall, there's an 8th Judicial District Court rule, I think it's subsection 3, that the attorneys are also supposed to get treats, and not just the jurors.
Mr. Mueller, you're welcome. You're welcome. I have a bowl of candy. Ms. Mishler, same for you.
Actually, I've
I
had,
appreciate
And there's some
that.
here too.
I believe I actually have.
All rise for the jury.
Thank you very much. Please be seated. Welcome back, ladies and gentlemen. Welcome this flight. As you know, due to a scheduling issue, was made aware to the parties during jury selection process, we did have to excuse juror number 3. So he will no longer participate in deliberations. I'm instructing you now that you should continue your deliberations with the remaining jurors, adding Ms. White to that equation. However, you should not consider the opinion of our excused juror in reaching your verdict. Whatever verdict you reach, it must be the result of this jury's thoughtful and careful consideration of all the evidence. That doesn't mean that you can't perhaps discuss some of the issues that were discussed yesterday, but ultimately the verdict in Beach has to include Ms. White in that process. All other previous instructions given to you will remain in effect. Give you a little bit of instruction about timing. Certainly, we're starting a little late this morning. I understand some of you got to experience the joys of the elevators. That is an ongoing issue in this courthouse. I'm glad everyone made it safely. But you will step back, begin or resume your deliberations, and we will have someone bring you menus for lunch in about an hour, hour and a half, so you will won't be hungry back there. And there are also some snacks for you this morning. Any questions from the jury? All right, thank you for being back this morning, and we can step back into the jury room. Thank you very much.
All rise for the jury.
Let the record reflect that the jury has left the courtroom. Any questions or anything we need to put on the record from the parties?
Not from the state, Your
All
Honor.
right, thank you. Thank you for being here this morning. We will keep you updated. Thank you.
Present, Your Honor.
Thank you very much. Please be seated. Ladies and gentlemen of the jury, I understand you have chosen a foreperson. Who is that person?
I am, Your Honor.
All right, good afternoon. Have you reached unanimous verdict in this case as to each count charged?
Yes, we have.
All right, could you please give the verdict form to the marshal? Thank you. All right, the clerk will now read the verdict of the jury.
District Court, Clark County, Nevada, State of Nevada, plaintiff versus Michael Lee McDonald, defendant. Case number C 333684, Department 9. Verdict. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 1, unlawful interception of wire communication. First audio recording is a separate wire communication from other recordings. No. Not guilty. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 2, unlawful interception of wire communication. The second audio recording is a separate wire communication from other recordings. Yes. Guilty of unlawful interception of wire communications. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 3, unlawful interception of wire communications. The third audio recording is a separate wire communication from other recordings. Yes. Not guilty. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 4, unlawful interception of wire communication. The fourth audio recording is a separate wire communication from other recordings. Yes. Not guilty. Count 5, unlawful interception of wire communication. The fifth audio recording is a separate wire communication from other recordings. No. Guilty of unlawful interception of wire communication. Signed this 9th day by the jury foreperson. Ladies and gentlemen of the jury, is this your verdict? So say you one, so say you all.
Yes.
All right, does either party wish to have the jury individually polled?
Yes, Your Honor, given the verdict, I think it'd be appropriate.
All right.
Juror number 1, is this your verdict as read?
Yes.
Juror number 2, is this your verdict as read?
Yes.
Juror number 3, is this your verdict as read?
Yes.
Juror number 4, oh, wait a minute, 3 was, you're number 4. Juror number 5, is this your,
Oh, he's.
you're number 5, right?
So, that's okay, remember we had a replacement, so we're just gonna restate it. So let's just to confirm, juror number 4.
Is this your
Sorry.
verdict as read?
Yes.
Juror number 5, is this your verdict as read?
Yes.
Juror number 6, is this your verdict as read?
Yes.
Juror number 7, is this your verdict as read?
Yes.
Juror number 8, is this your verdict as read?
Yes.
Juror number 9, is this your verdict as read?
Yes.
Juror number 10, is this your verdict as read?
Yes.
Juror number 11, is this your verdict as read?
Yes.
Juror number 12, is this your verdict as read?
Yes.
And juror number 13, is this your verdict as read?
Yes. All right, thank you. The verdict of the jury shall now be recorded in the minutes of the court. Ladies and gentlemen, on behalf of the court and the parties and your fellow citizens here in Park County, I again thank you for your service. This was, just shy of a week, but certainly it consumes all your time, and you were here late last night, so I thank you for your diligence during the course of this trial. As I said at the beginning, jury service is one of the only ways you can truly participate in our government, and so thank you for coming and doing your service. Like I told everyone else, you are now released from service for at least 18 months, hopefully up to 3 years, at least out of Clark County. I can't make any guarantees about any other jurisdiction. So I know the marshal informed you that I will ask you to step back. I do ask you to step back. I want to personally thank each of you and chat with you for a few minutes. At the end of this, when you are released, the attorneys may want to talk to you about the case. You do not have to speak with them if you don't want to, but you are free to. The juries understand, and I will direct them that they can ask you politely if you'll talk to them. But again, you're under no obligation to do so. If you do talk to them, I ask that you be mindful of your fellow jurors and the deliberation process. So you can talk about potentially what happened, but you don't want to single out anybody individually, but rather discuss the deliberations and ultimately the verdict if you so choose. So thank you again, and if we can all rise for the jury.
Does counsel want a copy of the verdict?
Yes, I do, and I'm going to formally,
Let the record reflect that the jury has left the courtroom. Mr. Mueller.
thank you, Judge, I'm going to have to formally move to set aside the verdict. Respectfully, the jury cleared him on 3 of the 5 counts. The other 2 counts literally is devoid of record. The conviction is based entirely on speculation, as was encouraged by my colleague, when she said basically at closing, well, who else would have made the conversations? We've been through 3 witnesses, all 3 of which said they don't know who did it, don't know when it was made, they don't know the details of the call, and it's quite literally an assumption that Mr. McDonald did it. And I'm going to move to set it aside. I will submit and send written points and authorities as soon as I have a chance to prepare them.
So do you want me to rule on that motion now, or do you want to write a written motion?
I'll get written points and authorities, but I'd like the record to reflect the motion is pending, and I'll support it with written points and authorities.
All right, then I will allow the state to lay record, and certainly you can supplement it if there is a written motion filed.
Thank you, Your Honor, and obviously the state would oppose such a motion. I believe defense counsel is misstating the testimony and other evidence from this case. The only witness who actually said anything about assuming anything was the detective, who was obviously not directly involved with the crime in this case. We have the testimony of 2 witnesses, one of which stated that he received these audio files from the defendant. The other one, Candace Ruiz, who listened to these files, and she testified that those were recordings of phone conversations that she had with the defendant, and she was not the person who recorded them. That is sufficient. Pursuant to numerous cases in front of the Nevada Supreme Court, if jurors believe the testimony of witnesses beyond a reasonable doubt, that is legally sufficient evidence. And my argument regarding who else would have made these recordings was in the context of telling the jurors that they could use their common sense and referring to them to their lawful jury instruction regarding common sense.
All right. I certainly will make a ruling on the motion as Mr. Mueller has advised to be filing a written motion, and so I will wait for the written pleadings and then issue a decision upon reading the motion, any opposition, and any reply thereto. Anything else that we need to address?
Your Honor, if we could ask Mr. McDonald be released on his own recognizance. He's got almost 9 months in custody on a case that's nonviolent, that is at best confused in the middle of heated divorce. Your decision won't matter, would practically matter. We still got another hearing in front of Judge Israel on the 15th.
I don't accept oral motions for release, so if you want to file a written pleading, I'll consider it at that time. that motion is denied without prejudice pending a written plea. Anything else?
Just a sentencing date, Your Honor.
Let's go sentencing date. March 4th, 8:30.
And just for the court's knowledge, he does have a PSI from his other case, so we don't necessarily need to.
The PSI, no, that's not going to work. The law's been changed. The burglary charges are going to be dismissed out of that case, and there's several other changes at X for the PSI.
Okay, well, we can go ahead and get another PSI, that's no problem. So we'll keep that date. So March 4th, 8:30 in the morning for sentencing.
And your staff has the laptop.
Yes, we will get that for you.
Great.
Thank you.
You both want a copy of this?
Sure.
Yes, if we can have one.
Appreciate all your efforts, Judge. It was
Thank you.
a very good trial for you.
Thank you very much. I appreciate everyone in the course of the trial. I'll see you all later. Thank you.
Okay.